Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. The judgment in the legal action between Ripple and the Securities Exchange Commission, SEC, is expected by the end of March, and the cryptocurrency world is eagerly awaiting it. USC. Attorney Jeremy Hogan tweeted on March 9 that it's possible that U.S. District Court Judge Annalisa Torres has already made up her mind on whether or not XRP is a security. Hogan, a pro-XRP attorney, came to this conclusion after pointing out that the judge referred to the securities law case Marine Bank v. Weaver at least 3 times in her most recent judgment while describing the viewpoint of XRP holders who purchased the coin. Hogan included a case sample in which he cast doubt on whether or not the item in issue was commonly understood to be a security. The latest order by the court at least 3 times addressed the case of Marine Bank v. Weaver in describing what a reasonable XRP purchaser thought when they acquired the XRP issue. When Judge Torres issued a 57-page ruling on the Doe-Bear applications both parties filed to exclude expert evidence from the summary judgment, the attorney made his argument. The court approved and dismissed parts of both parties' requests, so neither Ripple nor the SEC can claim victory. Judge Torres ruled that the SEC's main expert witness, Patrick Doody, who was supposed to evaluate XRP purchasers' expectations, could not testify. On the other hand, Ripple's experts about the differences between Ripple's contracts and those in the Huawei case, the tax treatment of XRP, the accounting treatment of XRP, and currency experts on XRP and currency experts on XRP were all permitted to stay on the record. While the Doe-Bear motion's judgment was split down the middle, Ripple's chief legal officer Stuart Alderoty said the company was confident in its case and that it would ultimately prevail. "We have been confident in our case from the beginning, and that confidence has only grown with each judgment," Alderoty added. Meanwhile, XRP supporter attorney John Deaton thinks the SEC made a big mistake by identifying Ripple executives Brad Garlinghouse and Chris Larson in its legal case. Deaton claims that the SEC should have investigated XRP's issue in business, Ripple, rather than going after people who aren't directly responsible for the alleged securities breaches. At first, Deaton claimed that the judge had said that SEC attorneys had put their own interests ahead of enforcing the law. The attorney expressed doubt that the SEC could enforce the law if its own employees disregarded it. According to Finbold's reporting, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernode, XRP, has predicted that the lawsuit might go one of 5 ways. Chamberlain thinks the case may end up settling, which would establish precedents about whether or not XRP and whether or not the court has jurisdiction over purchases made in other countries Ripple has already filed a letter in support of its fair notice defense, referencing a recent Supreme Court decision. The petition was submitted in reaction to a judgment that curtailed the authority of the United States government to punish citizens who failed to disclose foreign financial accounts to the IRS. Ripple highlighted the need for regulatory clarity in the cryptocurrency business by emphasizing the need of federal legislation, creating clear limits on what behaviors are illegal. According to attorney John E. Deaton, the United States Securities and Exchange Commission, SEC, action against Ripple might reach the United States Supreme Court before Congress adopts a regulatory framework for the crypto business. For perspective, the matter is now in district court and would need to be heard by the Circuit Court of Appeals before being heard by the Supreme Court. In a tweet today, the CryptoLaw creator stated this viewpoint that followed hints that the SEC had no intentions to slow down its aggressive crypto enforcement activities. Fox business writer Eleanor Terrett published an extract from the SEC's current budget plan. Significantly, the government adds that it will not hesitate to investigate and prosecute crypto businesses that it considers non-compliant. This, according to Terrett, signals that the regulator would increase its crypto enforcement section, which has more than quadrupled in size in the last year. Citing Terrett's conclusions, Deaton reiterates that the courts will be the sole source of clarification for crypto for the next 2 years. Although he acknowledges that it is not ideal, he insists that it is the current reality. Hell, before Congress acts, the Ripple case might be heard by the Supreme Court. Deaton tweeted, "We have to battle in court." In January, Deaton said that the highly awaited verdict in the Ripple case on whether XRP is an unregistered securities would provide the embryonic market with the only clarification it would get in the next 2 years. The lawyer presented this case by highlighting the polarization of Congress and the bitter taste the FEC's failure has left in MPS's mouths. Yesterday, the attorney representing thousands of XRP investors in the SEC complaint against Ripple as a friend of the court said that Judge Annalisa Torres' approaching judgment becomes more momentous with each passing day. He did, however, express confidence that the federal court will rule that secondary market transactions of XRP are unregistered securities. There is no precedence, according to Deaton, and Judge Torres is a stickler about obeying the law. There is no way the court will accept the SEC's unlawful premise that the asset itself is always an investment contract, Deaton said on Twitter. There hasn't been a case in the 80 years since Howard that makes such a conclusion. Judge Torres strictly adheres to the law. She refuses to find that secondary sales violate Section 5. According to Deaton, the only way the SEC can win its case against Ripple is if the blockchain payments company offered XRP as a security from 2013 to 2017. Judge Torres issued her decision on Daubert requests to prohibit expert evidence last week. It was largely seen as a Ripple success, with Ripple General Counsel Stuart Alderati claiming that the firm's confidence improves with each verdict. Deaton anticipates that the judge's decision on summary judgment will be issued shortly. A pro-XRP legal expert has weighed in on the SEC's litigation against Ripple, which seems to be nearing its end. On a March 10 Twitter thread, former lawyer and Evernote XRP co-founder Scott Chamberlain identified 5 possible outcomes for the lawsuit, including summary judgments, settlement, and further proceedings. The legal expert said the regulator didn't have anything near the evidence to suggest they intentionally or recklessly offered an unregistered security for Ripple CEO Brad Garlinghouse and co-founder Chris Larson's summary judgment. Chamberlain claimed that Ripple's sales of XRP on international exchanges are not within the court's jurisdiction and that an entirely new precedent would be created to declare those domestic transactions concluded in the U.S. for the summary judgment for Ripple. Chamberlain said that this lawsuit might investigate whether Ripple sold XRP tokens in the U.S. with unregistered investment contracts. The Evernote XRP founder's 5th possibility is that the dispute resolves if the court establishes precedence on XRP's security status and international sales jurisdiction. According to his reasoning, however, Judge Annalisa Torres ruled on both sides' applications to exclude several expert witnesses, including one that Chamberlain and Ripple's amicus curiae John E. Deaton thought detrimental for the SEC's position. New York Attorney General Letitia James sued KuCoin for acting as a securities and commodities broker, dealer without registering in the state, Feinbold reported. Former lawyer and Evernote co-founder Scott Chamberlain has 5 predictions concerning the SEC's lawsuit against Ripple. The Evernote co-founder thinks the SEC will lose its action against Ripple executives Brad Garlinghouse and Chris Larson. The SEC accused Ripple executives of assisting and abetting the selling of unregistered securities. XRP. According to crypto law founder attorney John E. Deaton, the SEC must establish that executives were reckless in not knowing XRP was a security. Chamberlain claims the SEC lacks proof. The former attorney said recognizing these as U.S. transactions would create a precedent. Third, the XRP Layer 2 architect predicts that the court will reject the SEC's allegation that XRP is a security. This suit attracted Deaton, who represents thousands of XRP holders, as a friend of the court. Chamberlain, like Deaton, claims the SEC lacks precedence. The former lawyer claims the regulator did this to avoid analyzing each XRP trade and addressing foreign sales. The former lawyer's last forecast is that Ripple's U.S. XRP sales included an unregistered investment contract. Chamberlain believes his 2nd and 3rd forecast will lead the SEC to settle. The former lawyer said the SEC underestimated Ripple's XRP sales abroad. The prolonged legal struggle is nearing its finish, at least at the district level, so curiosity over its fate is high. Deaton's forecasts and assessments mostly matched Chamberlain's. The attorney projected no out-of-court settlement until a summary judgment, finding to delay a trial or appeal. The crypto law creator also believes the SEC can only win if Ripple marketed securities from 2013 to 2017.